With the introduction of new technologies, the protection of individual privacy rights is a significant issue in Canada. As technological change has accelerated, the issue of preserving individual privacy rights has become an important issue for many Canadians. Today, I will discuss a recent decision of the Ontario Court of Appeal, which developed the tort of intrusion upon seclusion, or, as I like to call it, the Dr. Seuss tort. The facts of the case were as follows. The plaintiff, Ms. Jones, and the defendant, Ms. Sige, worked at different branches of the same bank. While both were long-service employees, they did not know each other at all. That is, until Ms. Sige started dating the plaintiff's ex-husband, Mr. Moody. Now, the relationship between Ms. Sige and Mr. Moody does not appear to have been the most trusting relationship. Problems arose because Mr. Moody apparently was crying poor, and he blamed his lack of funds on the fact that he had to pay child support to Ms. Jones. And for whatever reason, Ms. Sige's evidence was that she believed that her significant other was lying about having to pay child support. And she decided the best solution was to use her workplace privileges at the bank to see if Mr. Moody was telling the truth. Now, it appears Mr. Moody was not an employee of that particular bank, but Ms. Jones, the ex-wife, being a loyal employee of the bank, was also a customer. So Ms. Sige decided to access Ms. Jones's personal bank account, not just once, but 174 times during a 4-year period. I guess she really had to be sure that Mr. Moody was actually paying his child support. Ms. Sige's invasion of Ms. Jones' privacy ended only after she was caught by the bank. The bank disciplined Ms. Sige, but Ms. Jones was not satisfied, and she sued Ms. Sige, claiming a total of $90,000 in damages. The motions judge threw out Ms. Jones' case, finding that Ontario law does not recognize the tort of breach of privacy. Ms. Jones appealed, and earlier this year, a unanimous panel of the Ontario Court of Appeal ruled that this case cried for a remedy, which, as I've learned from Casey, they apparently often say, and decided it was time to recognize a cause of action for invasion of privacy in Ontario, the aforementioned intrusion upon seclusion tort. The Court of Appeal set out the following 3-part test for the tort. First, the defendant's conduct must be intentional or reckless. Second, the defendant must have invaded, without lawful justification, the plaintiff's private affairs or concerns. And third, a reasonable person would regard the invasion as highly offensive, causing distress, humiliation, or anguish. Now, the Court of Appeal made 2 important statements in an attempt to limit the onslaught of litigation under this new tort. First, the court stated that damages for intrusion upon seclusion in cases where the plaintiff has suffered no financial loss should be no more than $20,000. Ms. Jones herself was awarded only $10,000, far less than the total of $90,000 that she claimed. Second, the Court of Appeal noted that it did not wish to open the floodgates and that the new tort is only available for deliberate and significant invasions of personal privacy. The Court of Appeal provided examples of what would be a significant invasion of personal privacy, including such things as viewing an individual's financial or health records, information about an individual's sexual practices and orientation, information about an individual's employment, and finally, diaries or private correspondence. Now, while this decision dealt with 2 employees of the same bank, it wasn't really an employment law decision per se. And the extent of the impact of this new tort on employers' activities remains to be determined. For example, it remains to be determined if this decision will have any impact on employer investigations and surveillance, both in and outside of the workplace. Historically, the jurisprudence has drawn a distinction between surveillance in public, where there is no expectation of privacy, and surveillance in private, such as someone's home, where an individual has a reasonable expectation of privacy. This likely has not changed. It seems unlikely that surveillance of an employee in public will constitute a deliberate and significant invasion of personal privacy. However, it is possible that more intrusive surveillance or investigations, for instance, in an employee's home or accessing a private Facebook account or other personal records, may fall within this definition. And you definitely should not be reading your employees' diaries. Similarly, in a recent arbitration decision, arbitrator Surdykowski found that the Court of Appeals decision does not alter an employer's right to request or demand confidential medical information where appropriate. It also remains to be seen whether an employer can be vicariously liable for the actions of an employee under this new tort. The Court of Appeal described Ms. Seagay as a rogue employee and did not address the issue of vicarious liability. But it is certainly possible that in the future, a claim of vicarious liability could be made against the employer of an employee who commits the tort of intrusion upon seclusion. Obviously, a big concern is that this new tort will be relied on disgruntled employees against their employers in any and all circumstances, similar to how Wallace damages were always claimed prior to the Supreme Court's decision in Honda. Fortunately, there are several steps that an employer can take to reduce its exposure to potential liability. For example, employers should ensure that appropriate technology, policies, and practices are in place for monitoring company resources such as computers and the internet. Such policies ought to make employees aware that they should have no expectation of privacy when using company resources. It is also important to advise employees who have access to personal information that this information should only be accessed for legitimate work-related reasons, and that any inappropriate access may give rise to not only discipline, but as in the case of Ms. Seagay, potentially personal liability. Of course, employers should always enforce all policies consistently, investigate any alleged breaches of privacy in a timely manner, and impose appropriate discipline where a breach has occurred. Strive to catch an employee the first time they violate another individual's privacy rights, or, if that's not possible, at least by the 174th time. Thank you.